Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Beenleigh Magistrates Court. Client's been charged with driving whilst relevant drug present, which is legal terms for drug driving. So there's two types of drug driving. There's high-range drug driving, being under the influence of a drug. That wasn't the case today, but under the influence means you're high on drugs. And then there's the lower charge relevant drug present, which basically means traces of the drug were found in your system. So you're not under the influence, but you've consumed it at some point and it's still in your system. And penalty-wise, that's literally the equivalent of low or mid-range drink driving. So worst case, 9-month disqualification. Best case being the mandatory minimum is 1 month. So yeah, worst case 9, best case 1. That said, my client worked in a 100% driver's license dependent role, so I explained to him that I ordinarily push for the minimum 1 month for this offence, but even with 1 month, that would have wiped him out financially. So given that he hadn't lost his licence in the last 5 years, he was eligible to apply for a drug driving work licence, and that's what I was engaged to do. Just because you're eligible to apply doesn't mean that you'll get it. There's a number of hurdles that you need to overcome to persuade a magistrate that you deserve to be granted such an order. One of them is severe financial hardship. That's probably the easier of the two hurdles. But at the end of the day, you need to be able to prove that you're going to lose your income if you lose your job. And if you're employed by an organisation, I draft an affidavit up for the employer to sign, which literally states that you'll lose your job if you lose your licence. Occasionally I get employers, particularly in government organisations or multinationals, where HR gets involved and they become paranoid about the wording and they refuse to state that they're going to lose their licence, and they want to basically sit on the fence and see how the outcome goes and blah blah blah. And in those instances, I'll try to accommodate the request of the employer the best I can by watering it down. But at the end of the day, the magistrate needs to be satisfied that the affidavit addresses the law. And in fact, on several occasions, I'm not going to name the organisations, but I've had to summons employers to give evidence, because at the end of the day, an employer can give evidence by way of either an affidavit, or if they prefer, I can summons them to give evidence, meaning I issue them with a summons, I lodge a summons with the court. It's served upon the employer, and they must attend the work licence hearing court date, and if they don't, the magistrate's got the power to issue a warrant for the employer's arrest. So it's not a game, and some employers seem to think that they can play judge, jury and executioner and hold employees at ransom, but you know, there's more than one way to skin a cat, and if I need to summon his employer, I will. But obviously then in the private sector, that's a real quick way of getting fired. But then you've got the industrial relations law to help you out if you're unduly fired because an employer didn't want to sign an affidavit. But anyway, I'm prattling on now. That wasn't the case today. The employer was very cooperative and was very pleased with the first draft and signed it. Obviously the draft was based on instructions that I sought, but they signed it without any resistance whatsoever. I drafted, in addition to that, an 8-page affidavit for my client to sign, talking about income, expenses, family situation, what happened on the day in question, and sort of going back to what I was saying before about proving hardship. Basically, your income, the fact that you're going to lose it, and the expenses that won't be met if you lose the income. But the second element, which is the difficult one, and it's the one that people who are either self-represented or using lawyers that don't know what they're doing fall down on, is fit and proper person. So at the end of the day, you've been charged with driving with drugs in your system, so the assumption is you're not a fit and proper person to hold a licence, and you need to convince a magistrate that notwithstanding that, and notwithstanding whatever traffic history you may or may not have, you are a fit and proper person to be given a second chance. So in doing that, there's a number of things we do. I won't go into all of them now, but We get them to do the reformatory course that we get all of our clients to do. We get references. There's multiple steps that we get our clients to take to show to a magistrate that, notwithstanding what's happened, they are a fit and proper person to be given a work licence. Like, you see people going to court wearing a taxi driver's shirt, for example, and they sort of stand there as if to say, well, I'm wearing a taxi driver's shirt, enough said, I need my licence. Yeah, you've satisfied hardship. Yeah, you're a taxi driver, you need your licence. But now let's talk about fit and proper person, and just standing there with a taxi driver's shirt on isn't going to address or satisfy that element. Anyway, short version is, I was successful in persuading the magistrate to grant my client a work licence, but in addition to that, I was also successful in persuading the magistrate to give the mandatory minimum disqualification. So he got 1 month loss of licence, but overlapping that 1 month is a work licence order. So he's disqualified for a month, but during that 1 month, he's got special permission to keep driving for work purposes. And further to that, is this guy going to let me merge? Yes, he is. Further to that, given that my client was ex-military and I guess in the beginning of a new chapter of his life, I made forceful submissions on why it would be appropriate for the magistrate not to record a conviction. I'm not going to go into detail, I've already prattled on a lot, enough already, but the short version is I was also successful on that front. So there was no conviction recorded. In summary, 1 month loss of licence with a work licence order overlapping it, no conviction recorded, modest fine. My client's happy, his employer's happy. I'm Andrew Wiseman, and thanks for watching.
Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man.